Judge and Associate Judges now sitting en banc for the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated. Come to order.
Good morning. As was announced, this matter is before the en banc court upon application after certification by the trial court that this court addressing this matter en banc would aid it in its consideration of a complex case before it. At this time, that's case number 14 CV 1350, Motorola Inc. et al. Versus Michael Patrick Murray et al. Counsel, good morning. The court is prepared to hear from you.
Your Honor, I'd like to reserve 5 minutes for rebuttal.
Certainly.
May it please the court, counsel, my name is Terry D., and I am arguing today on behalf of the appellants. Your Honors, this case presents the first time that this court en banc has had the opportunity to consider the appropriate standard for the admissibility of expert evidence in the District of Columbia. Now, the purpose of evidentiary rules is to ensure that only reliable evidence goes to the jury. That purpose applies with particular force to expert testimony. Now, the court does not have to make this decision in a vacuum. It has the benefit of several things. One, it has the benefit of the Supreme Court's analysis of this issue in the Dauber case and the follow-on cases of Joyner and Kumho-Tyre.
Counsel, may I jump in and ask
Yes.
a question? When you said that the court has the duty to ensure that only reliable evidence comes before the jury, I guess 2 questions. Are you limiting that to only reliable scientific evidence? And then the second part is that intention, is there any tension between that thought, that statement, and the general rule that although courts have discretion to admit or not admit expert testimony, they generally don't weigh in on the underlying reliability, and that in many instances goes to the weight of the evidence, which we generally view as the province of the jury. Do you see any tension there in undercutting the role of the jury if the trial judge alone makes this determination that one person makes a determination as to what is appropriate or what weight, reliability arguably could be given to something that is admitted to the jury?
Understood. The answer to the first question is no. It's not limited to just expert testimony. This court has said numerous times in the Melton case, in the McCorkle case, that is the independent responsibility of the courts to determine in the first instance the admissibility of evidence. And the test for admissibility of evidence is whether it's reliable or not. And that is the purpose, in fact, the mandate from Rule 104.
Is it whether it's reliable or whether it's relevant and probative? I know you said 104, but what about 403 and that balancing role?
So there's 2 tests. The first test is whether it's admissible, and that test is whether it's reliable. The court has described that as all evidence must have an indicia of reliability or minimal reliability. There's a separate test, Rule 403, that is a last check, so to speak, and it applies to otherwise admissible evidence to determine whether this otherwise admissible evidence is more prejudicial than probative. So there's no tension there. It's the way the 2 rules operate: first admissibility and then the probative prejudicial analysis.
We already have that, though. Don't we already do that with the Frye test, 104 and 403 interacting together?
Yes, so you do have 403 along with the Frye test, but you also have 403 in the federal courts with respect to Rule 702 and the Daubert trilogy. Rule 403 is not a replacement for expert testimony. That's why jurisdictions like D.C. and the federal courts, every court, has a specific rule towards expert evidence to ensure that expert evidence is reliable 403 applies as a backstop to all forms of evidence, including expert evidence. So it's not a proper screen for expert evidence only.
So counsel, let's then go back and let's talk about expert or scientific evidence. And you suggest that this is the first time, of course, this court has a standard. It's a standard that's been developed over the years. It's commonly called Frye-Dias, but it's a standard in which cases that were decided prior to this court's development, the Frye test, developed by DC Circuit, has been supplemented by our own decision in 1977 of Dias. And in those cases, we've established a test for the admissibility, which presumes that the scientific methodology genuinely accepted leads to reliable evidence. And you've been talking about reliable evidence. Why isn't, in fact, that the case? It's still, a number of states still believe that it is a test that will present the best or the most reliable results.
So, yes, Frye initially was a test and established general acceptance of methodology as a proxy for liability. Over the experience and with the advances of scientific evidence coming into the courtroom, courts have determined that it is not the best test for reliability, and that's why you see the trend moving from Frye to Daubert, or to Rule 702 Daubert, because it is better equipped to handle scientific evidence. And the real reason why
Counsel,
rules...
I'm sorry, is there an argument to be made, I mean, there's a lot of talk about trends, but an argument to be made that DC is unique? I mean, we've had this rule for a long time. There's some suggestion in, I think, the trial lawyer's amicus brief that jurors or the DC population is particularly educated. 21% of people have a master's degree or more. You know, is there an argument to be made that DC is unique, and also in the sense that I haven't had this feeling that there's this real drumbeat or clamoring for 702, and there, you know, you do cite to the case from the 80s, I think, the Benedictine litigation and that sort of thing, but can you talk a little bit about why in DC this is so particularly necessary?
Well, my first point is DC is not unique in terms of the rules of evidence being there to ensure that only reliable evidence gets to the jury. So that's the point, that we want to make sure, whether it's in DC, whether it's in Illinois, whether it's in California, that only reliable evidence gets to the jury. And so the best test to do that is Rule 702. And I get into more detail about that, but I want to get to your second point, which is there's not a lot of clamoring. Well, there has been, you can see from the invited amicus briefs, you have the stakeholders.
I see that we have PDS, the U.S. Attorney's Office, and the Office of the Attorney General all are in agreement, but I'm not sure leading up to this, you know, over the past decades that we've actually seen that view from those institutions.
You have the benefit of their view at the trial court level, seeing that there is a problem here, that Frye has not been adequate in terms of screening out unreliable evidence, and you see problems with that in a number of different contexts that both the United States and DC and the Public Defender Service have pointed out in their briefs. You also have the benefit of Judge Weisberg's opinion and the struggles that he had with the Frye test applying to this type of evidence in a toxic tort case, where he pointed out that the Frye test doesn't really produce fair results in these types of cases, and he also described the Frye test as antiquated. And so you may not have seen the expression outwardly in terms of calls for change,
But I guess
but
we
you
wouldn't
do see
really
from
know.
the stakeholders
We
that
wouldn't
it's
really
necessary.
know until the end of this case if these experts did testify. You know, you don't know. My question is more about the trust of juries, something along the lines of what Judge Blackburn-Rigsby was asking we don't yet know in this case whether the jury would do its job in sorting through this evidence, right?
You
In a
don't
way
know.
that would satisfy even
You don't know. The purpose is to get to the right result, though. And the right result, and what the Supreme Court in the United States has said, what you're hearing from the United States Attorney's Office in D.C., is that the best test for determining the reliability of evidence is Rule 702 and Daubert, the Daubert trilogy. And the reason is this.
Counsel, I mean, I guess you could say, sure, you know, on paper, the best test is Daubert, right? I mean, because it seems to get at the question of reliability more directly, right? And who can argue with that, right? We want to look at, has this phenomenon been tested? Is it replicable? Is it validated? Is it peer-reviewed? Does it have an error rate? What is that error rate? All of those things in addition to general acceptance. And that just seems like a more comprehensive examination of the proffered expert evidence, right? And so that sounds really good. But as Judge Beckwith was saying, we have a system for vetting the reliability of expert testimony. It might not be the best one, but it's one that we've had and we've used for many, many decades, and we've accrued law around that system. And so there are other costs to changing the rules. And what about those costs? I mean, if we have a system that's okay and that is a decent proxy, in fact, you know, the general acceptance is part of the Daubert test, what about those other costs? Should we think about those when we decide whether or not to change the rules?
Well, if the costs we're referring to as the time and potential burden on Superior Court judges, our position is it's not going to increase that burden significantly. Courts
How can
already.
you say that? I mean, do you understand, you know, my understanding is that there's somewhere between, you know, 90,000 cases filed every year in Superior Court. Not everyone goes to trial, but say 1 in 10 does. That's 9,000 trials happening across the street. And, you know, you're analogizing to federal district court judges, but I can bet you they're not doing 9,000 trials in federal district court.
Well, you have.
And they're not taking experts where, you know, the expert testimony that's proffered is the drug expert, right? On how a drug deal is conducted, right? Do they take money, or, you know, where do the people stand? That sort of expert. Or the expert who's testing the marijuana, right? I mean, those experts are testifying day in, day out. Are we saying that they get Daubert hearings in all those cases?
Well, it's the same situation. We could take it out of federal court and talk about other state courts that have adopted, and the majority of state courts have adopted Rule 702 expressly, and a vast majority of courts apply 702, even if they haven't adopted expressly. And that's been going on for 20 plus years. You don't see the state court judicial systems in those areas that have adopted Rule 702 falling apart or not doing their job. You have 20 plus years of
Counsel, let's talk a little more concretely about costs that may be involved in making this transition. If we accept your invitation to adopt Rule 702, what about a well-vetted, well-established science like DNA? After we adopt 702, does the first trial judge who's been requested to introduce 702 or DNA evidence, does he or she have to go back to square one and do it all over again under Rule 702?
The analysis that would be done, general acceptance of methodology is an element of Rule 702. And to the extent that there is precedent in the appellate court decisions and superior court decisions that DNA testing, whatever particular test is being applied in a state, or in a case, is generally accepted, that can still be utilized by the superior court.
It can still be utilized, but it doesn't obviate the Daubert hearing, right?
No, there still has to be,
You would still have to have the hearing
you
if
have
it
to
were
have the
requested.
hearing to determine whether the DNA test was properly applied, or whether the conclusions that were reached, there's an analytical gap between the data that was looked at by the expert and the conclusions reached. The point being that that is what scientists look at to determine what is reliable science. And
But
what Rule 702
that's a
brings.
significant cost that we don't currently bear. If our case law says DNA is valid and it is admissible, you raise the question, the judge says, I'm going to let it in. He doesn't have a hearing to determine whether the science was reliably applied in this particular case. And so what you're asking for is a significant cost that we don't currently undergo.
Well, I would argue that the point that the Public Defender Service made so eloquently in their brief, and that is such careful scrutiny may be more difficult and time-consuming than simply counting votes, but the accuracy and fairness of our criminal justice system and the public faith in the system demand it. The point is, it's better to get it right in the first instance and do it and get that reliable evidence right than having to correct it on the back end and bring up the highly publicized Gates situation. There's a lot of time and money that has been spent in that type of situation where someone was convicted, spent 30 years in jail based on unreliable evidence. And that's far more a burden to the system and society than getting it right the first time through using a better test for the reliability of evidence.
What about the burden in the civil cases? I guess one criticism and one concern I have about a potential problem with the Daubert test is that it actually may have some impact on access to justice in civil cases. Even Judge Weisberg, in his order here, recognized that under a Daubert style 702 test, it might be more difficult, or it likely would be more difficult for expert testimony to come in against large corporations in these toxic tort cases and other types of civil tort cases. And you know, there is already, I think, some criticism that in the civil area, it is more difficult for plaintiffs in these large cases to be able to bring their cases fully to trial because of summary judgment motions and because of Daubert, like 702 gatekeeping by the trial court, where the jury never gets to hear the case. We don't get a decision on the merits. And while I understand and we even agree with some of what you said on the criminal side, I do have a concern about plaintiffs on the civil side, and I would call it an access to justice issue that might potentially limit their ability to bring civil lawsuits in these kinds of large cases.
Sure. Again, a couple points. Just one, pointing out that Daubert, Joyner, and Kumho-Tyer were all civil cases, and the first two were toxic tort cases. And that wasn't a concern of the United States Supreme Court, and it hasn't.
Well, it was a concern of Judge Weisberg's here, and he explicitly, I don't know if it was a concern, but he explicitly indicated in his order that that is a potential result in these types of cases.
It is. He also pointed out that the Fry case in these types of the Fry test in these types of cases can lead to unfair results. So I think he was pointing out the pros and cons of both tests, but there's no reason, no principled reason from a reliability standpoint to treat civil cases differently than criminal cases. And the point is that the economic stakes can often be very high, and we've seen examples where if you get it wrong, there's a real risk that helpful, good products can be driven off the market just by the fact that you have cases that are
Have you
relying on
seen a
unreliable
case like
evidence.
that in the District of Columbia where you would argue that the jury got it wrong because the science was not properly vetted on the front end?
In a civil case, the Bendectin litigation is one example, and Bendectin, the DC was one of the few jurisdictions, if not the only jurisdiction, that allowed in the evidence of Bendectin. Ultimately, after many, many years, got it right, but it was under Fry when all other jurisdictions at that time were recognizing that it wasn't.
Counsel, I think Judge Blackburn-Rigsby is kind of getting at another issue that's so puzzling about this case, which is that you seem to be, your client seems to be advocating for a position that might be sort of surprising if you sort of stepped back, right? Because, as you say, we shifted from Fry to Daubert in the federal system precisely to kind of liberalize the use of experts in these toxic tort cases. And, you know, one judge, federal district court judge said, you know, look, the whole purpose was to allow the admission of theories challenging existing orthodoxies, right? So the whole point was to allow plaintiffs, such as the plaintiffs in this case, to be able to prove up causation, and yet here you are saying, no, we want Daubert to be able to cut off their causation evidence, that is just puzzling to me.
It's not, the purpose was not to make it, I would argue that the point of Rule 702 and Daubert was to get the test right. And what you had a situation that the Supreme Court recognized, the Fry test was too rigid and austere. And the point that Judge Weisberg made is that that makes it over-inclusive and under-inclusive. So to the extent that it is under-inclusive, that's the point that Justice Blackmun was making in the Supreme Court decision in Daubert. But you also see it being over-inclusive. So the whole purpose of the test is not to make it easier for plaintiffs, harder for defendants, or harder for plaintiffs and easier for defendants. The whole purpose is to get the answer right, to make.
So this case, if you were to prevail, would go back on remand, and there would be a whole new round of discovery to allow the plaintiffs to get the information that they would need to litigate under Daubert, and then we would reach the right result, right?
No.
That's what you're comfortable with.
I'm comfortable going back and relitigating under the Rule 702 and Daubert, but it would not entail a whole new round of discovery.
Why not? I thought that discovery actually was limited because your client made the argument that, look, we're under Fry. All you need to know is general acceptance.
No, what
right?
happened
And then in
is.
fact that there were certain tests that your client had done that were discontinued, and there was definite curiosity on the part of the plaintiffs to get more information about those tests, and you said, you don't need that for general acceptance. So you don't get that information. Why wouldn't that be fair game on remand?
First of all, that's a misrepresentation of the record. We were required to produce those tests.
That's my misunderstanding of the record.
No, they asserted it in their papers, and it's not true. But the point is, in terms of what happened below, and by the way, I would point out, whatever happened below, what's not before this court is the merits of any discovery disputes or.
Sure, but we need to understand if you were to prevail, what the terms of the remand would be,
Yeah.
right?
So.
To give the trial court adequate direction as to what we think should happen if the case were to go back.
Well, one, I think Judge Weisberg has been through this process. He would be in the best position to determine what the next steps would be if this court were to say, let's go with Rule 702.
Right, well, I
and
mean,
he
just on
pointed out-
that point, he makes a statement of, it seems likely that the plaintiffs would fail under 702 Daubert, which I find a very curious statement, given that it was never litigated that way. So his ability to make that statement seems questionable, and it seems like we might need to make clear, if there were a remand, that needs to be subject to full-blown litigation.
What he said is also that all the discovery that could have been done with respect to general causation, and that was the issue below, had been completed. In his certification order, he said that if, for example, because the plaintiffs made the same argument in opposing certification, and Judge Weisberg rejected the argument, saying, I think pretty much everything on general causation, the scientific evidence has been presented to me. But if there's some way that we would need to adjust discovery going down, if this came down with Rule 702, he'd be willing to consider that, and he could make that call.
Counsel, I'd like to ask you a question about Judge Weisberg's order. We don't know yet what he understands Rule 702 or Daubert to require, but I'm wondering if there are certain negative implications in his order. For instance, he says The proper role of the trial judge is to verify credentials and methodology, not to weigh the persuasiveness of the testimony. If we shift to Rule 702, do you understand it to be the role of the trial judge to consider the persuasiveness of the expert testimony?
Well, not in terms of the merits, but in terms of determining whether in fact the evidence is reliable, yes. That he has to.
Drawing that line seems to me very tricky. And I understand you to be saying it is not the judge's role, though, to weigh the evidence and decide what he believes if it's reliably presented.
That's what courts have to do in all sorts of contexts, whether it's hearsay, whether it's some other admissibility rule with experts, and federal courts have been doing this for 21 years, and so have state courts, but
So do you agree that Judge Weisberg is not supposed to consider the persuasiveness of the expert testimony, even if we adopt Rule 702?
No, I don't agree with that. He
So
has to
explain.
make he heard testimony from the plaintiff's experts, and he heard testimony from the defendant's experts, and he has to make a call on credibility at times to determine whether what is being presented to him from the plaintiff's experts is credible or is reliable. And that's different from an ultimate determination of whether one expert's conclusions and opinions is more persuasive than another expert's conclusions, and that's for the jury to decide.
What do you say reliability means, counsel? What does it mean to be reliable?
In the scientific, in the Daubert context, it means to have used the scientific method, and that means scientific validity, that at each step of the process, from the beginning to the end, that each step is reliable. Because if any one step in that chain is unreliable, was not done validly, then that impacts the entire opinion. And that's the flaw with Fry, is that it only focuses, it puts blinders on judges to look only at general acceptance, when, as the Public Defender Service and the US and DC pointed out in their briefs, a generally accepted methodology applied improperly is no better than an invalid methodology.
Well, that answer suggests that maybe one approach would be to adopt a modified Fry as opposed to 702. I mean, if your concern is mostly about reliable application of principles and methods, you might do what some jurisdictions have done and keep Fry instead of throwing it out, but add a screening by the court of whether or not the principles and methods have been reliably applied. So why not do that? And I ask that in particular because although you said earlier that Fry is antiquated, you acknowledged in response to one of the questions that if the trial court is confronted with one of those methodologies that has been long used, generally accepted, let's take fingerprint testimony, for example. I believe you said, no, the court wouldn't have to conduct a full-blown Daubert hearing as to that. It would just need to look at whether or not the methodology was applied in a reliable way. So if that's the right answer, why should we not adopt a modified Fry as opposed to 702? And actually, let me add another question, which is this. What exactly is it that you want us to do? You want us to adopt 702? Do you want us to ditch Dias? We have said that the third prong of Dias essentially is Fry. Do you want us just to change that and keep the rest of Dias?
Sure. So
What
let
do
me
you want us to do?
let me take the first question on modified Fry. If this court were to adopt the same test as Maryland or Pennsylvania, those states that have applied a modified Fry test, that would certainly be better than the current Dias Fry test that the court has, that DC has now. Our position is, though, that the court should go ahead and adopt Rule 702 and not stop at the modified Fry test, because the modified Fry test, first of all, that those states import all the important material aspects of Rule 702 into their state's tests. So in those states, they look at application, not just general acceptance, but application of methodology.
That's one of the modifications.
Yes, and they also look at and recognize that conclusions aren't necessarily irrelevant to the reliability determination, and they see if they're, in the joiner context, whether there's an analytical gap between the data and reasoning of the scientists and the conclusions reached. So there isn't that much difference, but what you get is the efficiency and certainty of Superior Court judges knowing that when they are applying their test, they can rely on the Supreme Court precedent and on the 20 years of development of the standard, both in federal court and the state courts
I
that
guess
have
that sort of
applied it.
surprises me that that's your fallback argument, because you have so strongly advocated for getting rid of this general acceptance proxy assessment of reliability, and what you're saying is, oh no, that's okay, keep that, but then just tack on this, assessment of, is this methodology that's generally accepted but maybe completely unreliable, just to see whether it was reliably applied, and that seems to make not a whole lot of sense to me.
With general acceptance of methodology is not irrelevant to the determination of reliability. It's an important element. It's just not the sole element. It's not the only element, both in the scientific community.
I thought we were talking about a modified Fry scheme.
So in modified,
right? And my understanding of the modified Fry scheme is that you still look at general acceptance,
yes,
right, to decide whether or not the principles or methods are admissible. But then you also do this other, the last step of 702 to see how it's applied and see if it's reliably applied. But you're still retaining this kind of fundamentally flawed, I thought you were arguing, test of general acceptance.
well, it's fundamentally flawed in the sense where you just focus on general acceptance. That test itself is not fundamentally flawed. It's the fact that you rely solely on it to determine reliability. So the point is that with Rule 702, you add certainty. And one of the benefits that this court pointed out.
Let's take bite mark testimony and pretend that that were generally accepted still in jurisdictions across the country. And so under a modified Fry standard, what I understand you would be saying is, okay, you look at general acceptance, bite mark testimony is generally accepted, now let's look, is it reliably applied in this case? Well, we have a bite mark. This expert says he can discern, he can, individualize someone to a scientific certainty by looking at the bicuspids and the molars and whatever, and so it's reliably applied. Is that where we want to end up?
Well, then you'd have to look at whether the data was, again, the analytical gap.
I mean,
issue.
the basic problem seems to be, we now know that bite mark testimony is completely worthless,
No,
right? And so general acceptance doesn't help you there. It actually leads you to the wrong conclusion. The problem is actually in the Daubert-Frye distinction, not in the application, right?
I
Whether it's
understand your point.
reliably applied.
I
But
misunderstood
you're
your point.
saying as a backup position that you would be satisfied with modified Frye.
Well, one of the things about modified Fry or Rule 702, the general acceptance prong, it's not, you don't just assume, you still have to make sure, there's still the opportunity to look at that general acceptance, and is it still generally accepted within the scientific community? It's not the same as in DC
I thought the
currently,
argument,
which is-
though, had been made, though, that the problem with the general acceptance test is that sort of general acceptance, that the community, the relevant community is so insular. So all of the bite mark examiners in the country agree that bite mark testimony is generally accepted, and that's where we stop. And, maybe some other outside scientists actually say, the emperor has no clothes. This is not science.
So
But
to
it's
the-
really hard under a Fry test to attack that kind of now proven worthless forensic science.
I would agree with you that that is not ideal, and that's not what we're arguing for. Our point is that that's better. The modified Fry test is better than what DC has currently with Fry. But I think that the really important point is that, and this was made when the court adopted Rule 703 in the Johnson case, it did so, one of the reasons it did so, was it adopted the exact I'm sorry, not 703, 403. They adopted the exact wording of Rule 403 to, quote, gain for this jurisdiction the advantage that uniformity with the federal rule and the vast majority of state rules affords for interpretation and application.
But what is that, the value to that consistency with the feds? I know there's a lot of discussion in the briefs, which you call quibbling over which state goes along with, is in the dark ages with us and our antiquated Fry system or something, but we're just limiting to the federal courts. You suggest in your brief that there's a separate and apart from the merits of this, which framework is better, that there's an independent value in having a consistency with the federal courts. Can you talk a little bit about why that is? Is there a tangible advantage to us besides when I'm writing an opinion on this stuff, I can find some thoughtful federal appellate courts who are talking about the same thing under the same standard, but other than that, what's the benefit?
So the benefit is this, even though there are, the Rule 702 is applied on a case-by-case basis to the individual cases, individual experts, individual facts of those cases, that can limit the usefulness of the precedent. But you still have the fundamental determinations made by other courts in Bendectin, in cell phones, in other areas where they see how courts have looked at what is the proper way to apply this particular methodology and what have courts said is important, what is not important, how they looked at the analytical gap. Is it important in certain circumstances to consider only microwave energy as opposed to some other type of radio frequency energy? And that type of precedent is helpful to courts going forward and can be useful. And it would be particularly useful for D.C. Superior Courts to have that precedent of 20 years to fall back on during a transition to Rule 702.
Well, can I get back to the question about what, if anything, you want us to do about DIAS?
Yes.
Maybe you don't have a position on that, but if you do, I'd like to hear it.
I do. So the first two prongs of DIAS are essentially, substantively identical to Rule 702.
They are?
Yes.
I mean, the first prong of DIAS has a beyond the ken of the average layperson, right?
Yes.
And the first prong of 702 has specialized knowledge that will help the trier of fact.
Yes, but
It's
the
very
way,
different language, and
it's different
It's-
language, but the way it's been interpreted by the federal courts is that they
how about
use,
the way it's been interpreted here?
well, it's the same. My point is that the difference in the language
Do you
that
think
is
beyond the ken has been interpreted as a helpfulness standard in the District of Columbia?
I would say that the helpfulness standard has been interpreted as a beyond the ken standard in federal courts. So beyond the ken is the same, you have the helpfulness standard in DC and in the federal courts. And then both the second prong and federal courts, Rule 702, have the qualifications requirements. So really all we're talking about in this appeal is the third prong and the Fry test. So we would urge you to adopt Rule 702 because it already encapsulates the first two prongs of Fry,
Mr. D.
of DIAS.
Mr. D., I have the impression that the discussion so far has largely been in the tenor of, gee, we have a good test now, it's not perfect, but we could get a better test perhaps by going to Daubert and 702, but gee, there are all those costs. Could you take a moment and speak to the costs and the disadvantages in concrete terms of Fry? I'd be interested to hear you articulate for a few minutes why we should be dissatisfied and not happy with the results we're getting under Fry over the past 50 or 70 years.
Yes, so in Fry, and I think this is articulated very well in the Public Defender Service brief, where they talk about there are a number of examples where in this court there has been forensic technologies that have been generally accepted, that once those same forensic technologies were tested in a Daubert case, once Daubert came down in 1993, demonstrated that those forensic technologies were not reliable. hair sampling, and that's the Kirk Odom and the Donald Gates problem, is that for years and years, under Fry, hair testing, comparative testing, was treated as generally accepted. And that allowed unreliable evidence that has criminal defendants spending years, decades in jail as a result of unreliable evidence. And the Public Defender Service pointed out that almost half of the convictions that were overturned once DNA testing determined that there was exoneration there, half of those are a result of unreliable evidence being introduced in that forensic testimony introduced in those instances. So in that situation, that's evidence right there of the test isn't working. And you see it with other paraffin testing for gunshot residue was another example that was for years and years generally accepted within the District of Columbia, only to be shown later in Rule 702 jurisdictions that it was unreliable.
Maybe the answer there is that time passed, people learned more things. Suppose we'd gone back 30 years and the first time hair fiber evidence is offered, the judge had applied Rule 702. What makes you think it would have come out any differently based on what we knew then?
Well, there would have been more scrutiny. First of all, we don't know exactly what would have happened, but we know there would have been a challenge. In the Donald Gates and Kirk Odom cases, there was no challenge because that hair sampling was generally accepted. So then there would have to be an analysis subsequently of whether that hair testing, even if it was generally accepted, whether it had been applied properly. And I don't have enough knowledge of the facts, but my understanding is that those cases, it was not applied properly.
You know, in some of the briefs, there's a discussion of the potential of the 702 test to lead to these inconsistent verdicts as well, where you're constantly essentially relitigating the same science that had been thought to be acceptable. And I believe there's a discussion of the stroke cases resulting from the drug, I believe it was Pardol. Whereas the proponents of a Fry type standard would argue that Fry, in deciding it as we do here as a de novo issue, sort of, I think this goes to some of the discussion earlier by one of my colleagues, gives you a sense of stability where you're not constantly relitigating this unless there is a change in the science or new information. How does 702 help to safeguard from these potentially inconsistent verdicts using the same science that some jurisdictions have determined to be reliable under a Rule 702 test?
And Mr. D, when you answer that question, there are states that have specifically rejected it in measure because of the concern about the lack of uniformity. So, and responding to the question, perhaps to respond to the criticisms by those courts.
Sure. One is, first of all, I'm going to make the point that the Parladel example that the plaintiffs identified is, that appellees identified is, there isn't a inconsistency there because they were talking about different disease causations. So the opinions can be reconciled that way. But one of the benefits of Rule 702 is the fact that it is a more flexible standard. So you can take into consideration scientific changes that have been made in considering whether a particular methodology is generally accepted. You can take into consideration the facts of that particular case and what the expert did or didn't do. So it might look on the face as if there is inconsistencies between what two courts did, but in reality, those can often be reconciled by distinctions between the cases. And it's better to have the ability on a case-by-case basis to determine the reliability of evidence than have a whole slew of cases that are consistent but consistently wrong. And that's what you have with the Fry test, because you have only general acceptance, the blinders of general acceptance, without looking at whether there have been changes. sufficient changes to change the
Well, but
general acceptance?
that did happen over time. Perhaps it took longer under the Fry standard. In the example that you use about the hair follicle testing and its impact on certain criminal convictions, over time, with the change in what was generally accepted scientific practice, there were changes in the outcomes in those cases as well. What was the problem with that? In other words, once science caught up to the individual presentation of evidence in particular cases, the results changed as well under a Fry standard, as it perhaps fluctuates more frequently under a 702 standard, some would argue.
It would happen, point one would be, it happened much slower than it would have happened under Rule 702, because there would have been closer scrutiny of the methodology.
But isn't
Number
that how
two,
science works, though? Over time, it evolves, we get more knowledge, we get more information. We have, when Fry was decided in the 20s, we were looking at a early precursor to the lie detector test, and science has evolved over time, and perhaps it's evolving more quickly now, but I guess in response to Judge Glickman's question, I'm still not sure I'm seeing what the problem is with the test, which does accommodate changes in scientific evidence and discoveries over time, it seems.
one point would be that the delay between the scientific findings and its manifestation in courts is much longer under Fry. And second, it still doesn't take care of one of the other flaws of the Fry test, which is you're only looking at general acceptance.
Right,
You're
but
not looking at
there are
application.
delays in scientific discovery over time. I mean, in the Banc case and any of these toxic tort scientific cases, the science doesn't happen overnight. That's being challenged. So why should the evolution of the law addressing and reviewing these cases happen overnight at an arguably faster pace than the underlying science that is at issue in the particular case?
It doesn't happen overnight, but it does happen in a way that it happens as it should happen, but it gives the judge more discretion and more flexibility in making that determination at the right time. But that doesn't solve the problem of what any particular expert did with respect to that methodology in any particular case. If that expert didn't apply it properly or applied it in a way where there's an analytical gap.
Well, but Judge Weisberg did take some of these things into account, because he admitted only 5 of the experts that were proffered. And in one expert in particular, I believe it was Dr. Kumar, he said he followed the accepted methodology, but Judge Weisberg exercised his discretion under general discretionary principles under 403 and under 104 to say, however, this particular expert had a predetermined view of how things should come out, and therefore I don't know whether he used the word reliable, but ultimately he concluded that he would not be reliable and therefore excluded him. That seems to me what you want and what parties in these cases want to happen. Why can't that continue in that regard? What's the problem there?
Well, because
Mr. Dean, let me just, before you answer the question, your time has expired. I will give you some more time. I'm going to allow one more question after this question, but you can respond to that one.
Thank you, Your Honor. The problem is, Judge Weisberg said in his opinions, when he was evaluating the experts under the Dias-Frey test, that he could not look at how they applied their methodology. And so you had unreliable evidence going to a Rule 403 analysis, and it goes back to the point that Rule 403 is not the appropriate standard to be measuring expert evidence. It's a last stop check. And the example that I would point to why 403 is not adequate is the Jones case from 2010, where this court looked at the prosecution's expert testimony, determined that it was not reliable, but because the defendant had waived that argument, affirmed the trial court's use of that evidence, then did a 403 analysis in Jones, and let the evidence in, said it didn't satisfy Rule 403. So you had a decision where you had unreliable evidence, and Rule 403 didn't keep it out. It was admissible and deemed reliable under the Fry test, but because the 403 now, but under 403 it was let in.
Thank you. Judge Thompson, did you have one?
I wanted to pursue, I guess, my question about why a modified Fry wouldn't work just as well. And here's what I was going to ask you. I mean, it seems to me that we've heard arguments about sort of the aura of reliability that admission of expert testimony kind of confers, and that's why Fry is a problem, because it lets in generally accepted methods, even if they have been roundly criticized by, on the basis of new developments. They come in anyway. This does not lead us to truth, to reliable evidence. Why wouldn't this work? Sort of two things. We rely on Fry because it is a good proxy for general reliability, and moreover, it answers this point. I'm getting to my question, I promise, but I need to say a few things first. I think it is possible to conceive of a situation where you have respected scientists lining up on two sides of some point. This group says, I don't know, the European weather model works best. I have no idea how that might figure in litigation. I don't know, but I'm just trying to think of something where we routinely hear different groups of scientists supporting different things. So we have the European model folks over here and the American model folks over here, and pretty much everybody agrees that in each group you find respected scientists who have applied accepted kinds of principles, but they come to different conclusions and projections. And I say to myself, how in the world does a lay jury, if called upon to decide which of these is reliable, how does it do that? I don't know how that's done, and that partly explains my question to you about reliability. What's appealing about a Fry test, which looks at general acceptance, is that if you can say that something is generally accepted by the majority, well, you've got a good reason for putting it before the jury, because essentially you're letting them move on to the question of specific causation here. They don't have to decide a scientific question, which is really beyond their ken, quite frankly. So Fry has some real appeal. What would be wrong with keeping the Fry standard and looking at general acceptance of methods and principles, but having the court screen for evidence that no reasonable person could accept? That's a test that is known to the law. And then having the judge also say to the jury something like this: ladies and gentlemen, I've admitted this expert testimony, and I've done so because it's based on generally accepted methods and principles. And that's all I'm telling you about it. It's up to you, ladies and gentlemen, to determine whether you think this expert has reliably applied those principles, done so in a way that's obviously flawed. You're going to hear some cross-examination, and you'll hear some critiques of the methodology. It's up to you to decide whether you want to accept this. I'm just telling you, I've admitted it because it's generally accepted. And that's basically all I'm saying to you about it. What's wrong with that?
Well, because it advocates the role that this court has given to trial courts through adopting Rule 104.3 and what the court has called the quintessential role of judges, which is to determine admissibility, which is to make sure that you are only giving to the jury reliable evidence. And what Rule 702 does is it gives you a better test, gives the courts a better test to determine whether scientific evidence is reliable or not. So in your hypothetical, you're using an inferior test and therefore increasing the risk that unreliable evidence is being evaluated by the jury. And what the United States, what DC, what Attorney General, and what the Public Defender Service, what Judge Weisberg seems to suggest is that Rule 702 is the better test for screening out unreliable evidence and being true to this court's adoption of 104 and its definition and mandate to Superior Court judges that they make sure that only reliable evidence gets to a jury. You have the 21 years, or 20-plus years since 1993, when Daubert was announced, and you have the majority of courts and the majority in all the federal courts, all trending from Frye to Rule 702 because it's a better standard. There are exactly 0 jurisdictions that have gone from Daubert back to Frye and said Frye is better.
Thank you, Mr. D.
Thank you.
Because of the vigorous questioning from the bench, I will give you 5 minutes on rebuttal.
Thank you,
that you
Your Honor.
requested. Counsel.
Morning, Your Honors. Jeffrey Morgenroth on behalf of Appalese. I'll be sharing my time with Mr. James Green. I'll be doing 30 minutes and he'll take 15. I don't know if you want to...
It'll give it to you in just a
Okay,
second, but
thank
you
you.
can, we'll count down from 30.
Okay. In Melton, this court en banc held that Frye is an adequate test and it's an adequate safeguard. And it also held that juries can sufficiently weigh expert
Melton
testimony.
predates Daubert.
I'm sorry?
Melton predates Daubert.
Yes, Your Honor.
So we were kind of saying, in a vacuum, we like our test, but we didn't have an alternative before us.
I
And now
understand-
we do.
I understand, Your Honor, but the point is that nothing's changed since then.
Nothing.
Nothing has changed since then.
Okay, except that there's this whole new test that all of the federal courts have adopted.
Well, the reason why the federal courts have adopted that test is because Rule 702 has changed. What Daubert held was not that this Daubert test is better. It held that Rule 702 had been changed and it superseded Frye in the federal courts. And it looked to the Federal Advisory Committee, and the Federal Rules Committee indicated that the purpose of the change, the thrust of the change, was to be in accordance with the federal rules' attempt to relax the barriers for admissibility of expert evidence, expert opinion evidence. And what we hear from the defense
Well, not
is the exact
exactly
opposite.
relax, right? I mean, I think that that is just not helpful, right? I mean, because the point that has been made to us is that Frye is a proxy for reliability, right? Instead of assessing reliability directly through looking at things, at the evidence to see, can it be tested? Is it replicable? Is there an error rate? Is it peer-reviewed, right? Those are direct methods of assessing reliability, right? And instead of that, you have Frye, which uses this general acceptance test, and it's at once too permissive and too restrictive at the same time. So I find it unhelpful to say that it's more or less flexible. It's more precisely directed to the question that I think we're all interested in, right? We're all interested in having more reliable testimony in court.
Well, Your
Or do you
Honor,
disagree with that proposition?
no, I agree with that proposition.
Okay.
But
So
Your
I'm sort
Honor-
of curious that you are here because, the plaintiffs bar won in Daubert, right? They won big because they said, we want a more focused inquiry on reliability, and it actually helps us in these toxic tort cases to get that more focused inquiry. And yet here you are saying, please keep Frye.
Well, I do believe that plaintiffs bar won because what the Federal Rules Committee said is that they were relaxing the barriers to admissibility of expert opinion evidence. That was the purpose. And that's what Daubert recognized. And Daubert then said.
But
Rule
in
seven-
some respects, it also makes it more strict.
Well, that wasn't,
right?
that's not what the Federal Rules Committee determined when they
Okay,
were changing
But we have a
702.
Supreme Court case.
The Supreme Court case,
We're not bound by the Federal Rules Committee.
the Supreme Court acknowledged that. They didn't say Daubert was better. They acknowledged that the purpose was to relax the barriers for admissibility of expert opinion evidence. That's what Daubert said.
But the Supreme Court also, I feel like you're arguing with me on something that probably is not worth your time. I mean, the Supreme Court endorsed a very specific analysis of how you assess reliability. And they said, look, we're not laying out sort of a checklist, but these are the kinds of considerations that you need to take into account to assess reliability. We want to know, has this been tested before? Is it peer-reviewed? Is it replicable? Is it validated, right? Is there an error rate? All of those things. That's in the Supreme Court's decision.
I understand that, Your
Okay.
Honor, but there is not one Daubert test. The way it's applied in states and federal circuits is all over the map. So there is not just one test. And that's why in Judge
But
White's...
that's kind of the point, right?
Well, no, it's
I mean,
applied.
you're using it as a criticism, but it's actually kind of the point that we want, at the end of the day, we want trial judges to look at the scientific testimony that's coming in, you know, with an expert on the stand who's very credentialed and very persuasive to see, is this trustworthy, right? Do we want to, you know, we've got fact witnesses and we'll let fact witnesses, we don't vet them. We don't, you know, assess whether eyewitnesses to a crime are reliable or not. We let them take the stand and they are subject to the crucible of adversarial testing and confrontation, right? But for experts who have no direct knowledge, right, and who are coming in and saying, look, I have this specialized information that I can share with you, we have some gatekeeping, right? And that's why we assess reliability, and you're not seriously arguing that we don't assess reliability in some fashion. I mean, that's what Fry is for, right?
I agree. Fry actually assesses reliability. And
Well, it doesn't actually assess reliability,
Well, it
right?
does,
It does
because-
indirectly through a general acceptance
That's
test.
right. If the expert used generally accepted methods, it's determined that that's reliable enough for the jury to hear. And then the jury would determine.
It's
on
reliable
terms-
enough, except that now we've heard that it's kind of not reliable enough, right? I mean,
Well-
isn't that the message, one of, you know, all of these exonerations that we've now just heard about with scientific evidence that's been proven to be unreliable? And, you know, it took a long time. It took too long for that to come to light under a Fry test.
Well, let's look at
And then you also have in the civil context, sorry, but I want to have the full picture before you.
I understand.
In the civil context, you have Daubert, and you have the Supreme Court saying, we're keeping out too much new science that actually could prove causation in the toxic tort context, right? So this isn't a good test for reliability. This proxy is really not, it doesn't have good value. And so that's why we're going to give it up.
Well, if you look at the 11th Circuit, the 11th Circuit applies Dauber and has Rule 702. What the 11th Circuit says, it's a flexible approach, and if you satisfy the general acceptance and methodology factor, that in and of itself is sufficient. That's what the 11th Circuit says. That is the Fry test.
That seems wrong. I mean, maybe the 11th Circuit has applied it that way, and maybe the Supreme Court needs to review the 11th Circuit, but if you read Daubert, it seems hard to see how the 11th Circuit could have reached that far along in just saying we can look just at general acceptance,
Well-
because I can't see how you can read Daubert and Joyner and Kumho-Tyre and get to that conclusion.
Well, that's my point, that there's not one Dauber test, and across the board I can recite, how about the 8th Circuit? The 8th Circuit says that if, actually it says all scientific evidence should be admitted unless it is so fundamentally unsupportable to assist the trier of fact. That's their test. And they have 702, and they're applying Dauber. You look at the 3rd and the 9th Circuit, they say it's a flexible approach. And all of the factors are supposed to be considered, but there can be other factors to be considered as well, and some of the factors don't apply. That's the 3rd and the 9th
Mr.
Circuit.
Morgan, are you arguing here that, I mean, you are arguing in this case that Fry should be maintained? Is this a position that you take across the board? Is this sort of now the position of, well, your position generally and the plaintiff's bar position generally, or is it that the Rule 702 analysis allows for a Fry-Dias type test? I'm trying to understand, you weren't, you know, when you were asked by my colleague about Fry and about the seeming contradiction in your standing there as appellee arguing that we uphold Fry given how Daubert came to be. I'm trying now to understand, are you now articulating your position that Fry is in fact the best test for the admission of scientific evidence generally?
Well, I'm arguing for the affirmance of the Superior Court's decision on our Fry-Dias case, and that's for 2 reasons. One, just like the defense, we stipulated and agreed that Fry-Dias would apply, and we did that for 3 years. No one objected to Fry-Dias, no one sought review until after the decision.
So you're not here defending the application of Fry generally, just as it applies in your case?
Well, the second reason, yes, in terms of the application of Fry generally, it appears that Fry is working in the District of Columbia for decades. haven't seen any big problems. There have been uniform results. That's a problem with Dauber. There are inconsistent results because there isn't one Dauber test across the federal circuits, and I can get into the states are all over the board and how they apply Dauber as well. And every state that adopted Dauber had already adopted 702. So it goes hand in hand. It's not that they've determined Dauber is better test. When they adopt 702, the Dauber test comes in. But
Judge Weisberg seemed convinced that Dauber would be the better test. He said, I don't like what I'm seeing here. This is not good science, but I'm obliged to let it in. That's no way to run a court system.
I understand, and Judge Weisberg is a terrific judge, and he's a smart judge. But we didn't litigate the issue of general causation in science. All we litigated down below was whether or not our experts used generally accepted methodology. That was the sole issue. That's all we were allowed to do in terms of discovery. That's all that was briefed in terms of the briefing, with comprehensive briefs, and that's what the 4-week evidentiary hearing was about. Judge Weisberg didn't see the evidence on the science. We didn't litigate that issue.
If we were to remand, though, presumably you would have that opportunity. So I think we're more interested in hearing your defense of Fry than how you were prejudiced in this particular case.
And if you look at what happened in this case, Fry worked. And that's the second reason why I'm here arguing that we shouldn't change the standard, especially in our cases.
Why
Because
is
it
that a
worked.
good argument? I mean, clearly, Fry is not completely useless, right? I mean, if you look at a Venn diagram, right, you know, Fry gets it right this amount of time, and then Daubert gets it right this amount of time, and there's overlap. I mean, perhaps significant overlap, but why shouldn't we be concerned about the cases on the margins? Why shouldn't we be concerned about the decades in which criminal defendants were convicted based on faulty forensic science and under the general acceptance test? It just took a really, really long time for that to become generally accepted that this kind of science shouldn't come into the courtroom.
Well, I have 2 points there. The first is, it's ironic, if you look at New Jersey and Missouri, they maintain Fry for criminal cases, but they changed to Dauber for civil cases. And the reasoning was they wanted Fry, the more restrictive test for criminal cases, and they were relaxing the admissibility standards, the barriers, for expert opinion testimony in civil cases. So they came out the opposite way, and that's one of the problems we have here. That's my second point.
Doesn't that show that Fry is being applied differently all over the map?
No, they were applying Fry on more restrictive criminal cases because of the burden of proof.
Presumably to show that some of this junk forensic science is not generally accepted. Right?
Yes, and that
if Fry
Fry
is
is
more restrictively applied,
right, and
right?
it is not letting
But
the
if Fry
judge-
is more permissively applied here, and we apply Fry to allow general acceptance because we narrowly defined the body of experts who generally accept something, right? Then that's a discrepancy in the application of Fry, just as you're complaining about the discrepancy in the application of Daubert.
New Jersey and Missouri don't apply Fry differently than the District of Columbia. My point is that those jurisdictions...
So they also have a history of letting in faulty forensic science?
Well,
Then
I don't
that's
think
not
there's
a
a
very
history. I
good-
disagree there's a history of letting faulty forensic science. Here's the problem, Your Honor. There's no record. We didn't litigate the standard down below. We didn't have briefs on what standard's better. We didn't have experts testifying on that. We have no record. It was not litigated. The first time that showed up was in Judge Weisberg's 76-page opinion where he raised the issue.
Well, actually, I think it
So-
came up beforehand. I mean, I have a pleading from you where plaintiffs are saying, look, the defendants are trying to make a Daubert argument, right?
Well, what
But-
happened was,
But
just
I
before...
mean, I think there's no, in my view, there's no question that if there were a remand, plaintiffs would be allowed to litigate this. I'm much more interested in the issue of why you think Fry is a superior test to the Daubert test.
Well, my point, Your Honor, is a bit different. My point is that defense has made arguments. They make arguments based on articles and studies. Amici briefs have done that too, and we've cited to studies and articles as well. None of those have been vetted. We're talking about what standard is the best standard. Have any of those studies or articles passed Fry, Dias? Did they use generally accepted methodologies when they came to their conclusions? Are they reliable? I don't know. Would they be not admissible under Rule 403?
Counsel?
Maybe.
I may be repeating in a slightly different way a question you've been asked by my colleagues, but I'm trying to clarify in my mind what you are asking this court to do. I guess my thinking was that we were here to decide a purely legal question, which is whether the district should maintain its Frye standard for the admissibility of expert scientific evidence, or whether we should adopt the federal rules of evidence, Rule 702, and a Daubert standard. And I'm not sure I've had an opportunity to clearly hear your argument or your request or your response to that question. Should the
Yes.
legal question, I think I hear you going back to the facts of this particular case, but as a purely legal or perhaps partially policy question, why should the district maintain the Frye or move to the Rule 702 Daubert test?
Well, we're asking that the district continue with the Frye-Dias test, and there are 4 reasons why. 1, Frye-Dias standard worked just fine in these cases, and it's been working just fine in the District of Columbia for decades. 2, the Daubert standard has led to inconsistencies and confusion in state and federal courts, and there isn't just one Daubert test that's applied. It's all across the board, and I can give you examples in state and federal court in the circuits. 3rd, any change to the law in the District of Columbia should be prospective if there is to be a change, in order to avoid undue prejudice to these plaintiffs and to maintain the stability of law in the District of Columbia. And 4th, the manner in which the defendants are seeking to change the law in the District of Columbia, that would diminish litigants' right to a jury trial. And we need to be careful about that. So we would request that Frye-Dias...
I'm sorry, can you explain that last point?
Yes. Juries are the province of the jury is to adjudicate facts. That's a constitutional right. And it's been recognized in the District of Columbia and other states and federal jurisdiction that...
Does the jury have a role in adjudicating reliability or just facts here?
They adjudicate facts, they adjudicate the conclusions, they weigh the evidence, they weigh the credibility of the witnesses. That's the jury's province, and that's done through vigorous cross-examination.
Under the Frye test, we assess reliability. It's not like we are in a jurisdiction where we just have hands off and say, we're not going to look at reliability at all. We leave it to the jury. The jury will decide, right? We don't do that. We screen for reliability through the proxy of general acceptance. We've got Frye.
Yes.
Under Frye and Dias, you have a beyond the ken of the jury test, right? You actually have to show that the jury would be so unfamiliar, confused by this. You have to surmount that threshold under our Dias test, even to get expert testimony in. Now, maybe that doesn't matter in your case, because this is pretty technical stuff. But if we're talking as a matter of law, we're looking at a legal question, do we get rid of Dias-Frye and adopt 702 Daubert? Which is more favorable to juries then? If under 702, the standard is, would this be helpful to a jury? We don't demand total ignorance or confusion. If we think the expert testimony would be helpful, we let it in, or it passes muster under that first prong. So I'm having a hard time with your sort of juries need to decide this. 1, because we already do remove things from juries' views. And 2, under Frye, there is this very, under Frye-Dias, there's a pretty strict threshold requirement.
My point is the manner in which the defendants want to change the law, that would diminish the rights of litigants to a jury trial, because what they are really arguing here is that the judge should be looking at the conclusions of the expert. That's what they're arguing. The judge isn't supposed to be looking at the conclusions of the expert, not even under Daubert. Daubert itself holds that it's only the scientific principles and methodologies that are in play. That's what's to be looked at. And under Frye, that's the same, whether or not it's generally accepted. not the conclusions. And what they're arguing is that this is junk science because their conclusions are so out of whack. And therefore, we should take into account what the conclusions are, and all of these experts should be excluded.
Mr. Morganroth, I noticed that in the 4 reasons that you've given us just now for continuing with Fry and Dias, you don't mention reliability. Let me ask you the following question. Suppose my concern is to pick the test that is more likely to avoid miscarriages of justice based on reliance on invalid, unreliable pseudoscience. Which test, in your view, is better and why?
Well, my view is that the Fry-Dias is better because it's been proven to be workable and leads to uniform results. The problem with Dauber is there's not one test. It's all over the map. And judges have a difficult time applying Dauber because of the fact that there's no framework or guidelines that they can adhere to.
Mr. Morgan, with respect to that question, as you answered Judge Clinton's questions, you keep referring it to Dauber. What about 702? Because is there consistency since 702 versus consistency since Dauber? As you, again, in your response about why one test would be better than the other.
No, there's no consistency with 702 because every state that applies Dauber adopted 702, and that's the reason why they're applying Dauber. Dauber is the interpretation of 702, and then it was codified in an amendment of 702 later. So every single state that
That's
applies...
what I'm talking about, the fact that it was codified in an amendment to 702 more recently than either Dauber. The question is, when you articulate this confusion and this inconsistency, you keep using Dauber. And now there's been a codification that includes the trilogy, and the question is, if we were to adopt 702, not Dauber, 702, would you still be making the same arguments about inconsistent application?
Yes, absolutely. And that's what I'm using 702 and Dauber interchangeably
Okay,
because
just wanted to
Dauber
make sure.
interpreted 702 when it was initially changed, and then it was codified to apply to the trilogy of the cases. So for instance, South Dakota adopted 702, the state of South Dakota, and what they do is they have extreme leeway for the court to determine how to determine reliability of expert testimony. Mississippi, that adopted 702. Mississippi says you have to satisfy every single reliability factor of Dauber. Oklahoma also adopted 702, and what Oklahoma says is that it's a flexible approach, and that you're to consider factors. There could be more factors than were espoused in Dauber, or some of those factors don't apply. It's up to the judge. So you have, and then you have Massachusetts. So
I'm still failing to understand why it's so confusing, because the ultimate inquiry is this expert evidence reliable? That's the question, right? Under Fry, the question is this generally accepted? And it's not like that's an easy question to answer all of the time, right? I mean, you don't always have the single meta-analysis that just shows you, oh, this is what 100 scientists agree upon, right? So you've got, is it generally accepted? Is this reliable? And then we have ways of figuring out how things are reliable, but it really kind of depends on what the expert testimony is, right? Are we talking about tire treads? Or are we talking about toxic torts? So it means that there's flexibility, but there's extreme clarity as to what the ultimate question is, and we're looking at and focused on and ultimately very concerned with reliability. Why is that so confusing?
Well, the question's the same in District of Columbia and in Fry states as it is in 702.
It's not the same.
Yes, the question is whether or not the evidence is reliable. The way you do that.
Where do you find that under die-Frias? I'm sorry. Where is that
That's
language?
the third factor. And the way you do, well, it's more than the third factor because first you would look to make sure that the
The
expert's
third
qualified.
factor, if I can just remind you of the language, is that the state of the pertinent art or science is sufficient to permit an expert opinion, meaning you have a determination that there's general acceptance of a particular scientific methodology.
Yes, and what this
And
court has
that's
said in Banc and Melton is that's an adequate safeguard to determine the reliability of expert opinion testimony. That's the purpose of the third factor in Dias.
But you're not actually, the question is not actually, is this evidence reliable? The question is only, is this generally accepted?
The question is whether it's been generally accepted
stop.
methodology in the scientific community. And then as what Judge Weisberg did, he made sure that the expert was actually performing that generally accepted methodology, and they were doing so in an appropriate manner.
So,
And he sought the
what
experts.
if, hypothetical, last month, some new test was published, new methodology that shows, and it's good evidence, that there is a causal connection between cell phones and the brain tumors in this case? Would you be here saying, preserve Fry, don't adopt Daubert?
Well, the problem with the hypothetical is you would look at what methodology they used, not that conclusion. And that's the problem with the defense argument here, and that's the problem with Judge Weisberg's opinion, because they're basing it on the conclusions. And Dauber and 702.
Yeah, totally, but under my hypothetical, totally new methodology, some revolutionary new, interesting way of figuring out that there is a causal connection, but it's completely reliable.
And
There's some brilliant scientist who has
we
thought up
had
this
that in
way.
this case, Your Honor. That's the leading
Okay, but it's not generally
biophysicist.
accepted because it's totally new.
That's the leading biophysicist
So that
from
would not
Greece.
come in under Fry.
And that's right, that happened. Our expert was stricken in this case on that very scenario. And so did one of the
And-
tests of another expert,
And
Dr.
yet,
Bellia.
you are now saying that you would like to preserve Fry and preserve the ruling, keeping your expert out that has this very powerful evidence.
Well,
I'm
I
perplexed.
think we would be stopped from arguing the opposite, since we litigated this issue for 3 years and stipulated that Fry Dias applied, and so did the defense.
Morgan,
3 years.
you were about to argue, I thought, that somehow, piggybacking on questions that were presented to Mr. D, that somehow the court is already equipped through 403 and 104 to make these types of calls on whether the evidence should get to the jury on a basis other than scientific, the generally accepted methodology that was used to present presented under Fry Dias. Could you
Yes.
continue with your
Yes, Your
response to that?
Yes, so the reason why we argue that Fry Dias worked here is because 5 experts were admitted based on the fact they used generally accepted methodology, and there's no dispute about that. The defense doesn't argue that Judge Weisberg applied Fry Dias wrong. They don't challenge those rulings as to the general acceptance of methodology, and it's not a question or dispute that they actually performed that general acceptance methodology. Now, there are 3 experts that were excluded. One expert is a Johns Hopkins trained epidemiologist. And what the court found, what Judge Weisberg found is A, she didn't use generally accepted methodology, so she was out. B, he found that the methodology she performed was barred by 403 based on the manner she performed it. And then I believe Dr. Khurana was referenced by Judge Blackburn-Rigsby. Dr. Khurana is a Mayo-trained Australian neurosurgeon. He was excluded. Now, he was determined to have used generally accepted methodology by Judge Weisberg. The reason why he was excluded, because Judge Weisberg found that under 403, the manner in which he applied that generally accepted methodology was more prejudicial than probative. Even though he didn't accept it, scientific methodology, the manner he performed it got him excluded. And then the third expert that was excluded is a leading biophysicist from Greece. He was excluded by Judge Weisberg because Judge Weisberg found that he did not use a generally accepted methodology because a portion of his laboratory test was not used by enough scientists to make it generally accepted, even if it was reliable. Even if it caused reliable results, it wasn't generally accepted.
You're not
So-
saying that Rule 403 is equivalent to Rule 702, are you?
No, I'm not, Your Honor.
Rule
I'm s-
403 is a much more relaxed screen than Rule 702 would be, right?
Well, no, actually, 702 is supposed to be a relaxation of the barriers for
Well, maybe a
disability.
different screen, let's put it that way.
I agree with Your
Be
Honor.
better
It's
to
a
say
different
different.
screen, it's a backstop to make sure that the expert is not only using generally accepted methodology, but the manner in which they use it is appropriate way and is not prejudicial. And it was specifically used in this case to exclude two
The
experts.
things we normally look at when we apply Rule 403 aren't the things we normally look at when we evaluate the reliability of scientific opinion testimony. A scientist, for example, evaluating somebody else's science, wouldn't be focusing on whether the jury might be confused, or whether it would be a waste of time, or whether it would import prejudicial information unfairly. Scientists would be looking at scientific things. And Rule 403 doesn't speak to those things, does it?
It does not, Your Honor. It speaks more broadly to all evidence, and it can be used as more prejudicial than probative. And the way it's been used by Judge Weisberg on each one of our experts was to determine whether or not the manner in
We're not
which...
here to examine whether he did that correctly or not, I have to admit.
Let me ask you a question about prospectivity. I understand from a practical point of view that you wouldn't want to change to 702 to apply to your case. How would that prospective-only argument square with the purpose of an interlocutory appeal, which is to establish the law for the particular case?
Well, I understand Your Honor's tension in the question there, and there's a problem here because we did litigate this for 3 years.
You didn't have any choice but to do that. That was the governing law, and Judge Weisberg was obliged to apply it.
Well, either side had the opportunity to object to an application of Fridays instead of drafting case management orders and inserting it at every step. And actually, the defense filed a motion limiting discovery based on general acceptance of methodology only. Each side had an opportunity back then, when the first case management order was entered into, to seek interlocutory appeal 3 years ago, more than 3 years ago now. No one did that. We litigated, spent an enormous amount of time, enormous amount of the court's time, enormous amount of dollars, and plaintiffs are dying. 3 years.
I suspect if you'd appealed from the case management order or sought an interlocutory appeal, we would have said this is way too abstract. We don't have any record to flesh out the controversy. Go away.
Well, that may have happened, I don't know, because no one did that. Instead, everyone stipulated to Fridays, and we litigated that. Now, there have been states that have dealt with this or addressed with this very issue. Kansas, what they did, and so did Alabama, they amended their expert admissibility standard prospectively. That's essentially accepting 702, but doing it prospectively through rulemaking. Schaffersman in Nebraska, what that court ended up doing, they applied Fry to the case at hand on appeal and actually reversed the lower court's decision on Fry and then applied Dauber prospectively to trials that would take place for a period of time after.
It seems to me your best argument is to compare what we're being asked to do to what the federal courts did with respect to Rule 702. They adopted it prospectively. They amended it to take effect at a future date. But here we're engaged in case-by-case adjudication.
And Your Honor, that's an interesting point, because if you look at North Dakota refused to adopt Dauber. And the reason why they refused to adopt Dauber is because they didn't believe that it was appropriate for a judicial decision to change or adopt 702 or Dauber, and that it should be part of their rulemaking process, and they should actually do a study and have committee appointed and analyze the situation, and they've never adopted 702 since, or Dauber. It's a valid point here only to the extent that we don't have a record. There's been no expert testimony on which standard is better. Both sides are citing standards or articles or studies. None of those have been vetted. We don't know if those are reliable in and of themselves.
You know, usually when we talk about prospectivity, we mean future trials. There is a sense in which If we were to adopt 702, we would apply it to you prospectively because you haven't had a trial yet. If Judge Easterly is right that you would get to go back and do some additional discovery, it sounds even more fully prospective. So what's wrong with that?
And I understand that, Your Honor, and that appears to be what they did in Schaffersman. They applied Fry to the experts, reversed, and then said that Dauber will apply prospectively, and it appears that they were going to go back for remand for a trial, and Dauber was going to be applied. We certainly would need to have full discovery if the standard changes here, because the only discovery we were allowed was on general acceptance methodology. But I would point to Oklahoma again, the Romano case. And what they determined was they adopted 702, and they adopted Dauber, and they refused to apply Dauber retrospectively or retroactively to any scientific technique or method that had already been determined to be valid under Fry. So, and I think that would work for our cases, because our experts have already been determined to be using the correct scientific method, and they would, quote, be grandfathered in. And then prospectively, any other scientific technique or method would be applied.
Are you
pursuant
talking
to Fry.
about expert by expert or discipline by discipline?
Scientific study and.
You're saying because your experts have been vetted and deemed admissible under Fry, they come in, or are you saying any expert who testifies on this subject matter who's previously been deemed permitted to testify about that subject matter?
What I'm saying is Romano did it by scientific technique and method.
How do you square that with Daubert? I mean, 702 Daubert seems like the whole essence of it is that you're looking at it case by case.
That's true. I'm addressing the perspective.
But I
versus
understood that you were
retroactive.
saying that in this other jurisdiction, they have just walled off certain disciplines.
And that's my point. There is no one Dauber. And in fact, look at Massachusetts.
Has any federal court done that?
Well, the 11th Circuit says
Walled off disciplines?
if it's generally accepted methodology, that's dispositive.
Fingerprint testimony, bite mark testimony, ballistics testimony, not subject to Daubert. It was already generally accepted before, no problem with us now.
I believe that's the 11th Circuit. If it's generally accepted methodology, that is dispositive, and that's in and of itself good enough in any court in the 11th Circuit. And Massachusetts does the same thing at state court. Massachusetts says, we will apply Fry, general acceptance methodology. If you pass that, you're in. If you don't pass it, we have a fallback. And that fallback is you can apply Dauber, because if maybe Fry was too restrictive, we'll apply the Dauber factors and see if it can get in that way. And maybe that's an alternative. If this court wants to change the standard, maybe that's the alternative. Fry Dias has been working just fine. If it's too restrictive, where we're not letting in on your hypothetical new scientific technique that's reliable, well, that's the Massachusetts standard. That's exactly the Massachusetts standard, which is general accepted methodology, you're in. If it's something that's brand new and you can't satisfy that, you know what? We'll apply the Dauber factors.
Mr. D, thank you very much. Your time has
Thank you.
expired. Mr. Green?
May it please the court, good morning, James Green for Appellate. With the time I have remaining, just to urge a consideration of the Massachusetts standard to this court. In the 40 years that I've been a member of the bar of this court, I believe Fry has worked very well, although it has been a hard standard at times to meet. But and when we go across the street, we try to meet that standard. In this case, this court is being asked to review our standards and is being asked to review them on a very incomplete record from below. That's a problem for the court. It was a problem for us in our briefing, and frankly, it's been a problem, I think, with the formation of questions of the panel. Putting all of that aside for a moment, and my complaint aside for a moment, I urge that this court consider if it is going to in any way affect a change in the Fry standard. Although it can certainly do it en banc without question, a consideration might be for a committee to be appointed by the court to study this exact question. My concern springs from The number of experts that we have utilized in our briefing, that the Defender Service and the government and the Attorney General and appellants have utilized in their briefing to suggest here is the problem with, or here is not a problem with Fry, here is a problem with, or here is not a problem with 702 and Dalbert.
You know, if we
we
were to
can't-
set up
I'm
such,
sorry?
if we were to set up such a committee, you know, it would be comprised of, I'm not sure that we've ever done that before, because, you know, we don't have rules of evidence. This court creates the rules of evidence. So, but it would be comprised of judges and then institutional players, such as the United States Attorney's Office and the Office of the Attorney General and the Public Defender Service, and we have their views.
Yes, Your Honor.
So I'm not quite sure what creating a committee to further reflect on this question would get us, other than more work and delay in resolving what standard DC should have in assuring the reliability of the evidence in its courts.
Your Honor, there's no question about it would entail more work. But with respect to the standard of review, it wouldn't necessarily just be an advocate's position. You would have the ability to test the reliability of the information being presented by those studies, such that you could determine whether or not there is or is not a problem in some objective way beyond our briefing. And that's all I am suggesting to the court. The court can certainly act on Banc. I am well aware of that, and of course, I would follow, as we all would, whatever the court would do. But I am suggesting it to you as a possible thought. It may not catch on at all, but it's a thought with respect to this that I wanted to offer this morning to my court.
Mr. Green, if we don't adopt that approach, is your alternative argument that this case isn't ripe for our consideration right now? Am I hearing you arguing that until such time as this case is tried, a verdict is in, we won't know what was the outcome of the evidentiary rulings by the trial court, because the trial court could, though allowing general causation, have made specific causation evidentiary rulings that would lead to other appeal issues?
Frankly, Your Honor, we didn't argue that position to this court. Do I feel that way? Yes, because the record isn't complete. But nevertheless, with respect to standards that we would use for the admission of evidence in our courts, I would urge a consideration of a standard that is reliable, and if it is reliable, that is to say general acceptance with equal reliability under Fry. If it is not then found to be generally acceptable, then a fallback position perhaps, which would be an examination like Massachusetts in Lanigan 1 and Lanigan 2, those cases that would suggest that you can look at the standard and get an answer for the trial court.
How is that so different from 702 Daubert? I'm sorry, because under Daubert, you can look at general acceptance, right? You're also supposed to more directly look at measures of reliability directly, if you can, right? If they exist. If they don't exist, then maybe you can and you're left with general acceptance. But at the very least, what Daubert does is it focuses the mind on the ultimate question of reliability instead of redirecting the attention to some proxy question that might not get at the answer as directly, right? So I'm not quite sure I understand what the difference is that you're saying this Massachusetts test would.
My problem, Judge, let me be clear if I can. 702 is the adoption of that standard. Daubert is the case as I have analyzed that, as we all have. The Daubert standard, number 4 by Justice Blackmun, is the reliability standard. It mirrors our Fry ruling, our Fry jurisprudence here, and it incorporates that in that rule. So I guess I'm suggesting that
Mirror sounds strong. I mean, I think it incorporates part of Fry, right? Daubert says, or Daubert, however you want to pronounce it, says, look, we want to assess reliability, and sure, we're not going to throw out general acceptance. We'll keep it. It has some utility, but it's not the only or best question to ask.
I risk the word mirror because I believe it is strong. I believe that the general acceptability, the general acceptance within Judge Blackman's opinion, and then within the advisory committee, and then within the recodification.
If you read the opinion,
post-
it's the very first factor he says is, we want to know, can this be tested?
Yes.
He doesn't say, we want to know, do experts generally rely on,
He says
generally
that-
accept
he
this?
says that-
That comes, it's in there for
It's
sure.
number 4. He only gave 4, and it's number 4. And that's why I think we have to look at that and not, I think our Fry jurisprudence here informs that. And I think the judges of the Superior Court, and I offer it to this bench, that the judges of the Superior Court would be able to utilize their working with Fry, as would lawyers across the street every day, be able to utilize their working with Fry to achieve general acceptability. And if it defaulted, that the witness did not bear on that, or the science was something we needed to test in a different way for reliability, then we could do that, and we could do it within, and I'm suggesting that the court might look at the Langen cases in Massachusetts. My brother has suggested the North Dakota cases. There are others, but we would urge a consideration of that. If we can't
So
study.
this is a different sort of modified Fry
Sure.
that you're saying.
If we have to go, if the court feels that its jurisprudence under Fry needs to be looked at, I'm urging as a member of this bar that we look at it in that way.
Mr. Green, let me ask you to
Yes, sir.
educate me about Massachusetts. What if you have a discipline that is of long-standing, historically admitted, generally accepted, but the current thinking is that it should not any longer be generally accepted? How would you raise that challenge under the Massachusetts approach?
As I appreciate it, Your Honor, you would raise it by saying that it's no longer accepted, and that you would be able to
But
challenge
I
that.
thought you had characterized the standard as saying, if it is generally accepted, it comes in, no further inquiry.
Yes, sir. And where I was going with that is it comes into the practice of the trial. The adverse parties then challenge that standard in Massachusetts. They have their own experts. The witness may still testify because they've been found to be generally accepted, but the validity and the challenges and the tests that we have all utilized our entire lives in this profession. Cross-examination, opposing witnesses, maybe Rule 403. In addition to that, briefing, motions in limine, motions post-judgment, all of the things that we ensure in our system to protect the integrity of our system exist there. So under Lanigan 1 and Lanigan 2, that would be available under, I believe, your hypothetical, Your Honor.
But you're changing the issue. That is, Fry and 702 go to the question of whether the evidence will be admitted. I understood you to say under Massachusetts in my hypothetical, you would admit it and test its reliability at trial.
Yes, Your Honor, that's what I was saying. That would be my understanding in response to your hypothetical.
Thank you.
My brother has made all of the points we were going to make with respect to our position on this case. I'm happy to take any other questions from the bench, but I would ask at this time that the court affirm the finding with respect to our witnesses and remand the case for action below. I thank you.
Mr. D. We'll let you continue with the rest of that time.
Thank you.
You get an extra 27 seconds. Go ahead.
Thank you, Your Honor. I just want to get back to the core of the issue here, which is what is the better test, Rule 702 or the Fry-Dias test? And the points that Mr. Morgenroth made, one was that he focused on the inconsistency in the way that Rule 702 has been applied. The question I would ask is, if Rule 702, if that's a real downfall of Rule 702, why have the majority of the state courts adopted Rule 702? Why are none of them saying, this is so confusing, let's go back to Fry? In
Can you
21,
explain the 11th Circuit's decision? Counsel, Mr. Morgenroth suggests the 11th Circuit basically ignores Rule 702 and the Daubert decision and applies a strict, it sounds to me, Fry, not even one that is modified by other considerations as we have here and as other states have done. Is that your understanding of the 11th Circuit's approach to implementing Rule 702?
No, that's not my understanding of the 11th Circuit. I think what is one of the strengths of the Rule 702 test is that it is flexible, and the Supreme Court made it clear that no one factor may be controlling. In fact, none of the factors may be controlling, and they're not exclusive. So in any particular case, if the evidence of general acceptance of a methodology is so overpowering, certainly that could be an important decision in that analysis.
So to Judge Fisher's earlier question, DNA evidence, you would argue no need, in fact, the trial court could deny a motion for a Daubert hearing or a 702 hearing on the admissibility of that evidence because it's so generally and well accepted in the scientific community?
I would not agree with that because you still have, under a proper Rule 702 analysis, you have to look at not just the general acceptance piece, but you should look at how it's applied and whether it's applied reliably and whether the conclusion is there's an analytical gap between the data and rationale.
So basically, the representation about the 11th Circuit is, in your comments, that it would be an important piece are not necessarily to the exclusion of the application and the reliability test that we find under Rule 702.
That's right. And the second point is that Mr. Morgenroth said that Fry worked below. Well, Fry didn't work below, and if did work below, Judge Weisberg wouldn't have certified this for interlocutory appeal. He clearly feels it didn't work below. You can sense you see from the exact language in his opinion that he says Fry does not produce fair results in this type of a case. The third point Mr. Morgenroth said is that that it works in D.C. Well, if it works so well in D.C., why do you have all the stakeholders, the Public Defender Service, the U.S. Attorney, and D.C. Attorney General, who litigate the majority of cases that involve this type of evidence, all coming into court to urge you to adopt Rule 702, and not a modified Fry, but a Rule 702.
Counsel, I'm sympathetic to Mr. Morgenroth's point that 702 Daubert mean different things to different people. They seem to be applied differently in different cases. We don't yet know how Judge Weisberg conceives of that test. If we rule in your favor and then remand, do you think we are obliged as a matter of good judicial management to explain what we understand Rule 702 to require?
I would say, with respect to Rule 702, if you adopted Rule 702, that is not required. If you were going to adopt some sort of modified Fry test, that would be required because there would be confusion and clarity, which is one of the advantages of adopting Rule 702, is that Rule 702 has 20-plus years of experience, and you have Supreme Court precedent.
One exercise that is informative to me is if you read the advisory committee notes under Rule 702, it blows this way and it goes that way, and there's a little bit of this for everybody, and you're left saying, well, we'll make it up as we go along in a particular case.
And that would be maybe the view if you were back in 1993 and trying to adopt Rule 702 and Daubert and the advisory committee notes. But we have we have other Supreme Court cases, it's been pointed out, and we have Rule 702, and this court should adopt Rule 702 as it has been interpreted by the United States Supreme Court, and other jurisdictions that have applied Rule 702 can provide authority, perhaps persuasive authority, in terms of how it should be applied, but the court should, given the scope of Rule 702 and the purposes, and to eliminate any confusion for the Superior Court judges, actually adopt Rule 702 in whole, as the Supreme Court has interpreted it.
Why do you think Judge Weisberg thought Fry didn't work? I have heard it said that Judge Weisberg thought Fry didn't work because it led to admissibility of some expert testimony that didn't that doesn't agree with the conclusions reached by the IARC and the other list of organizations that you set out in your brief, what would you say was Judge Weisberg's reason for
Well-
concluding that Fry didn't work, doesn't work?
Sure. One of the points that Judge Weisberg made is that with the advance of modern science, you have disciplines like epidemiology, which rely more on inductive sciences, inductive reasoning, more subjective views of the experts than deductive science. And so, for example, the judge pointed out that when you have in such a subjective framework like epidemiology or literature reviews, you just say a literature review is generally accepted without analyzing what the expert did in reaching the opinion, then you actually are resulting in a situation where unreliable evidence comes in. His point is deductive science and inductive science are different, where you're talking about quantitative issues that are apparent in deductive science, then Fry might work well. But when you're talking about subjective opinions, and epidemiology was a big part of the case below, his view was it doesn't work that well.
So if we were to adopt 702, just as to finish up that thought, you take from his opinion that he believes that in those areas where deductive reasoning or social sciences, epidemiology, and those sciences are better served, but also the more quantitative sciences would also be well served by that, even though you now suggest like Fry may work well for those sciences.
And that's because the test for general acceptance, the Fry test, is built into Rule 702 analysis. So you still have the strength of the Fry test for deductive sciences built into the Rule 702 test. You don't lose that. This court,
Your time has expired, but I'm going to let you finish up.
sure, I was just going to say that this court has set forth the factors in Laumer of what it would look to determine whether to adopt a new evidentiary rule. In our briefs and today, we have identified all the reasons why each of those factors has been met and supports adopting Rule 702 in this case. And as the Public Defender Service so succinctly put it on their brief in describing the trial court's gatekeeping role, Daubert and Rule 702 will enable trial courts to perform this vital gatekeeping function more effectively. So we urge the court to adopt Rule 702 and bring DC's expert admissibility standard into alignment with modern scientific evidence. Thank you.
Thank you, Mr. D, for your argument. Mr. Morgan, thank you for your argument. Mr. Green, for yours. The case has been submitted, or this issue has been submitted, and we stand adjourned.
All right.